You got served. You're holding a summons and complaint, and you need to know what to do right now. Here's some crazy news. 83% of people sued for credit card debt in New York City never respond. That's from court data covering hundreds of thousands of cases filed between 2019 and 2023. When you don't respond to a lawsuit, the court may enter a default judgment against you, and that judgment lets the plaintiff take action to collect and enforce that debt, such as freeze your bank account, garnish your wages, or put a lien on your property, all without you ever walking into a courtroom. That non-response rate is exactly what the debt collector is counting on. Many people lose not because they owe the money, but because they don't know about a specific New York law that makes thousands of these lawsuits legally dead on arrival. In a few minutes, I'll show you how to check if yours is one of them. By the end of this video, you'll have a 5-step checklist to protect yourself and 3 real options for resolving this, including one that wipes out this lawsuit and every other debt you have in a single move. Quick disclaimer, everything here is general information, not legal advice. Your specific situation needs specific legal analysis before you make any decisions. So be sure to speak with an attorney to discuss the particulars of your case. Section 1, understand what you're holding, the summons and the clock. You should have 2 documents in front of you. The summons tells you what to do and when. The complaint tells you what the creditor claims you owe and why. Before you do anything else, look at the top of those papers for the words consumer credit transaction. That phrase confirms this is a debt lawsuit filed in New York City Civil Court, and it triggers specific rules that may work in your favor. Rules you're going to use. First, your deadline. You have 20 days to respond if the summons was handed directly to you in person. This is known as personal service. If the summons was served by any other way other than personal service, then you have 30 days to respond. Alternative methods of service may include if it was left with someone at your home, taped to your door, or mailed to you. The clock starts the day it was served, not the day you found it or the day you read it. But even if you count those days perfectly, there's a trick used right here in the 5 boroughs that can strip your right to defend yourself even before you start. We're gonna check your affidavit of service in a moment to make sure it hasn't already been used against you. Right now, before this video ends, do this. Count your days from the service date and put the deadline on your calendar. Then add a second reminder 5 days earlier so you have actual time to act on it. This one move already puts you ahead of most people in your situation. Why? You now know how much time you have to explore all the different ways you can respond to this lawsuit and choose the one that best suits your circumstance. Now, going back to the affidavit of service, it's a document the process server filed with the court claiming they delivered papers to you. Sometimes those affidavits are false. Process servers have filed affidavits describing people who don't exist, physical descriptions that don't match the defendant, and service dates when the defendant was probably somewhere else. This is called sewer service, and a 2025 investigation found it's widespread in New York City consumer debt cases. Pull out the affidavit attached to your papers and check 3 things: the date, the address, and the physical description of the person they claim to have served. If anything looks wrong, write it down. These details could matter later. Section 2, the fast checklist before you decide anything. Step 1 was adding that deadline to respond to your calendar so you know what kind of window you have to figure out your next move. Assuming you've done that, next, run through these 4 checks before you make any decisions about how to handle this. Step 2, figure out who's actually suing you. Look at the plaintiff's name on the complaint. Is it the original creditor, Chase, Capital One, a bank you recognize, or is it a company you've never heard of? That unknown company is likely a debt buyer, meaning they purchased your debt for pennies on the dollar and are now trying to collect the full amount. Debt buyers have to prove in court that they legally own your debt, and they have to show a complete documented chain of ownership from the original creditor to them. A lot of them can't do it. That's a real defense, and it starts with knowing who filed the case. Step 3, run a statute of limitations check. Find the date of your last payment on this account, or the date the account went into default. Under New York law, the statute of limitations for most consumer credit transactions is 3 years from that date of default. Pull up your old statements or check your credit report for that date. If the lawsuit was filed after that window closed, this case may be time barred entirely. Don't assume, verify this with a lawyer, but knowing that date before your consultation is exactly the kind of thing that saves you time and money. Step 4, gather everything. The summons, the complaint, the affidavit of service, any old statements, any letters or collection notices you received. It doesn't matter which of the three options you end up choosing, you need this paperwork whether you're defending the lawsuit, negotiating a settlement, or filing bankruptcy. Step 5. Check the debt collector's license. In New York City, most debt buyers are required to be licensed by the Department of Consumer Affairs, and they're required to list that license number on the complaint. If you don't see a license number, or if the company isn't licensed when you look them up, that may be a defense. You can verify online in about 2 minutes. Here's what doing these 5 steps actually means. You're already ahead of the 83% of people who get sued, do nothing, and wake up one morning to a wage garnishment or a bank account that's frozen because of a default judgment entered against them. Doing nothing is the one move that guarantees you lose. Now that you have your paperwork together, you might be tempted to call the debt collector's lawyer right now and try to work something out. Hold off until you hear option 3 because it's the only one that can guarantee they can never sue you again for this debt or anything else you owe. Section 3. Your 3 options: defend, settle, or discharge. Most people try to handle their debts one by one. One lawsuit, one settlement, one collector at a time. For a lot of New Yorkers, that's probably the most expensive way to do it. I'm going to show you a math shortcut that wipes out this lawsuit and every other debt you have in a single move, and why it doesn't actually stop you from buying a home later on. But first, let's go through all 3 options so you can see exactly where you stand. Option 1 is defending the lawsuit. Before your deadline to respond to the lawsuit, you file a written answer with the court. You can do this without a lawyer. New York City Civil Court has a process for answering in person at the clerk's counter, and there's a free form with a list of defenses you can check off. Filing an answer forces the plaintiff to actually prove their case. A lot of debt buyers buy these accounts in bulk and don't have the paperwork to back it up. When you answer, you find out fast whether they do. But having defenses isn't the end-all be-all, because that requires you to know what to look for, as well as things you'll have to prove with admissible evidence. Things like the debt buyer can't produce a documented chain of ownership from the original creditor, or the affidavit of service has details that don't match reality, or the lawsuit was filed after the limitations window closed. You can spend a lot of time, money, and energy defending against a lawsuit and still lose. Only now you've added to the amount of money you're out of pocket. For instance, if you receive a summons alleging that you owe $3,000 on a credit card, you could try and hire an attorney to defend you, but that's money you're likely paying up front, and maybe just as much as the claim itself. You could choose to try and defend against it, but consider the days you'll have to take from work to appear in court, going through possible discovery, trial, and even after all of that, you still may lose the case. In many cases, choosing to defend against these credit card lawsuits is the most time-consuming and most expensive of the options. Option 2 is negotiating a settlement. You contact the plaintiff's attorney directly and try to resolve it for less than the full amount claimed. One thing worth knowing, under civil evidence rules, settlement discussions can't be used against you in court, so you can have that conversation without being held over you later. Debt buyers often have room to negotiate because they purchased the debt at a fraction of the face value. Getting to 40 or 50 cents on the dollar might be realistic in some cases, but the number that actually matters isn't the percentage, it's whether you can actually afford it, and whether paying one debt still leaves you buried under others. Many creditors, if they are agreeable to settle a debt for less than what you owe, will only accept a lump sum payment. Whatever you agree to, get it in writing before any money moves. Consider our $3,000 lawsuit example. You can try calling the plaintiff attorney and ask if they'll be agreeable to settling a claim for an amount you propose. If they agree to 50%, they'll generally want that paid up front as a lump sum. So unless you have $1,500 available, this may not be a good option. Additionally, you don't want to send money over unless you receive a written agreement clearly outlining what's being cleared up once they receive the money. Last thing you want to do is send over money because of a conversation you had with the rep over the phone, and then they'll proceed with the lawsuit because you have nothing in writing. Option 3 is bankruptcy, and this could be the option that changes the entire math of your situation. Here's a concrete example. Say you owe $3,000 on this lawsuit and another $12,000 across 2 or 3 other credit cards that you're behind on, but you haven't received the summons from them yet. That's $15,000 total across 3 or 4 different creditors. Settling each one separately means 3 separate negotiations, 3 separate agreements, 3 separate payments, and months of stress while collectors keep calling. A Chapter 7 bankruptcy handles all $15,000 in a single filing. The moment you file, the automatic stay kicks in and stops all collection activity immediately. Every lawsuit, every call, every garnishment attempt. Most unsecured debts get discharged in about 4 months. Many people avoid this because they've heard they'll never be able to buy a home or get credit after filing bankruptcy. This is absolutely not the case. Many people file for Chapter 7 and can qualify for mortgages in the future. I've represented many people who've done just that. The fear of bankruptcy keeps people paying collectors for years longer than they need to, often spending more than the bankruptcy would have cost in the first place. This just adds years of stress and struggle with daily living. Now, Chapter 7 may not be for everyone. If you have significant assets you need to protect, or your income puts you above the eligibility threshold, it may not be the right fit. That's exactly what a free consultation is for, to look at your full picture and figure out which of these 3 options actually solves your problem. For many people, after running through this 5-step analysis, realize that filing for bankruptcy is the cheapest, fastest, and most complete way to get out of debt and obtain a financial fresh start. Going back to the example of someone with $15,000 in credit card debt, even if they settle all the claims at 30%, that's almost $5,000 that they have to pay as a lump sum to creditors, with 3-4 different settlement agreements. While attorney's fees for bankruptcy may vary, many bankruptcy lawyers in the New York City area, including my office, generally charge significantly less than $5,000 for a Chapter 7 bankruptcy case. A credit card lawsuit in New York City doesn't have to be an automatic loss. You only lose automatically if you do nothing. If you live in the 5 boroughs, the law office of Richard Kistnen offers complimentary virtual bankruptcy consultation. The link is in the description. If you've recently received a summons, then book your complimentary bankruptcy consultation right now so you can stop spending your energy worrying and start mapping out a plan of action. Remember, everything in this video is general information that should not be construed as legal advice, and your situation needs specific legal analysis before you make any decisions. So be sure to speak to a lawyer about your specific case. Now, maybe you found this video too late and already have a default judgment against you. That judgment leaves you susceptible to a wage garnishment or a bank levy. Chapter 7 bankruptcy can actually void that judgment entirely. Watch this video right here to see exactly how you may be able to wipe out a judgment and protect your property.